pleased and honored to be on the same panel as Judge Gordon Atchison, who on my screen is to my right. I don't know what it's like for your screen. And Judge Sarah Warner, who would be to my left, as I see these things. All three of us have been on the court for some time. And I can tell you, counsel, that we have read your briefs and we have received a memorandum of law from our research staff concerning your case, and we've read that as well. I see that the Chief Judge has granted extra time to this particular case of 20 minutes. And I can tell you right now, though, that we won't punish any attorney for not using all of their time. So if you feel like you have completed your argument, you don't have to wait around until your time has expired. But we are familiar with the facts of this case. And even though it is extra time of 20 minutes, I would suggest that you get right to it because we might have some questions. And so to help us out, because you understand this record, you've lived with this case for a lot longer than we have. And so you can help us in our inquiries. With that in mind, then, let's have the appearance from the appellant counsel.
This is Carrie Josserand with Lathrop GPM. I'm here. I represent Safeway, although I'll be speaking on behalf of both appellants. Mr. Gottfriedson is Kraft's attorney. His wife is ill today and he's unable to participate.
All right. And are you wanting time for rebuttal?
Yes, please. I'd like to reserve 5 minutes.
5 minutes, you've got it. That's one of my onerous duties as a presiding judge. I get to keep track of the time. So I'll make sure you get that. And if we could have the appearance of Appellee's counsel.
Good morning, Your Honors. Michael Pospish on behalf of the Americold Appellees.
All right. Very good. Well, counsel, we'll get started here. I'm going to say right now that I used to be on the Board of Law Examiners. And back in the days when we used to write out questions for all examiners. And I remember one year my assignment was civil procedure. And I'm going to have to say that this particular case would make a wonderful bar exam question concerning judgments and procedures. And so with that in mind, I'd like to hear from the appellant counsel and tell me, how did the district judge get it wrong?
Thank you. May it please the court. And I will say first, I am very happy that this was not on my bar exam because I'm not sure how well I would have done with a complicated case like this. This district judge got it wrong, Your Honor, because he granted summary judgment on the basis of res judicata. And although at first blush that seems that that's the correct answer, this is not a correct application of the doctrine of res judicata as this. And this is the question, one of the few limited questions that this court took up when it granted interlocutory review in this case. As the court is aware of the facts of the case and the long history of this case was filed in 2012, but it was a previous case and has been up the federal court system and back and came back to Wyandotte County. 2 years after the case was remanded, Americold filed for summary judgment on the merits of the case and also on the basis of res judicata. The district court in Wyandotte County, and I'll be trying to be clear when I'm talking about district court, which district court I'm talking about today, made one finding that the case was barred by res judicata. However, the doctrine of res judicata, which is claim preclusion, by nature exists for the purpose of preventing multiple lawsuits over the same transaction or occurrence. You can't go and file cases in whatever court you want to until you get one gets a result that you like. However, this is not a second cause of action. This is not a collateral attack. This is the same cause of action. The parties went up the chain in federal court and came back, and all of the parties showed back up in Wyandotte County and litigated for 2 years. Res judicata simply does not apply to later proceedings, and this court, or actually the Supreme Court of Kansas has recognized that in multiple cases. It discusses that in the State versus Collier case and the Clayforth case. This is the same lawsuit that resulted in the October 13, 2013 judgment, and the same lawsuit in which that judgment was vacated. Res judicata is also only effective when there is a final and valid judgment of a court of competent jurisdiction. And this
Counsel,
yes.
Before you move on,
Yeah.
You said something, and I just wanted to clarify. You said that the parties already moved up and down the federal ladder and have now come to Wyandotte County, but that's not entirely correct, is it? I mean, your clients stepped out of the litigative ladder, if you will, by not filing an appeal from a federal decision.
That's correct. Our clients did not appeal the summary judgment ruling from the federal district court in 2013, if I get my dates correctly. They did not.
And so in that respect, your clients didn't, I guess, sojourn on this odyssey up to the United States Supreme Court and back.
No, they did not. They did not. But when the case then was remanded with the directions from the 10th Circuit, the judgment, October 2013, was vacated. And
now, let me ask you, I've got a question for you about that. As I understand it, the U.S. District Court, and I'll try to keep the district court straight myself, the U.S. District Court followed very closely the mandate rule, saying the 10th Circuit says we don't have diversity jurisdiction because of the technical rules of concerning a real estate investment trust. And therefore, we are setting aside and remanding, correct?
Yeah, they said yes, remanding with directions to
actually returning it. They can't remand it to.
They returned it.
They returned it. Now, if that is so, the 10th Circuit did not have jurisdiction over your judgment, the judgment against Safeway and against Kraft, did it? Because it did not address that case.
It did not address the judgment, but it made no specific instruction to vacate only as to parties. They made to vacate the judgment. And then the district court vacated the judgment, referencing the date of the judgment with no reference to any of the parties.
Well, you see, my problem is the only thing that I see that the U.S. District Court dismissed was the judgment against Conagra, because that is the party that the 10th Circuit had jurisdiction over, and that was the judgment that was the subject of the mandate, and the district court was following the mandate rule. And so I don't see how you can argue, unless I'm completely wrong on the facts, that the judge dismissed the judgment against the summary judgment that was granted back against your two clients.
Well, the exact wording that the the 10th Circuit used was this court remands this case to the district court to vacate its judgment on the merits and remand the matter to state court. And then the district court vacated its order, period.
Mhm. And you take it to mean that that was the judgment against you as well.
Correct.
Okay.
That is our argument. And if the judgment was void, which it was, then it needed to be vacated because the judgment.
There is no doubt. I mean, if we were to talk about the law of the case, when the U.S. Supreme Court says that the court had no diversity jurisdiction, then the U.S. District Court was without jurisdiction, and that was a void judgment. Correct?
Correct.
Because it was a judgment of a court that had no jurisdiction. So under the law, that's void.
Yes.
But my problem is, you see, I think they're referring to the only case that the U.S. Supreme Court had in front of it was the judgment against Conagra.
That may be the case, but the district court, the federal district court, it's all back in front of that. We actually had a pending motion in front of the federal district court.
Yes,
under Rule 60B.
You had a rule motion, which I wanted to address as well, because if your judgment was dismissed along with the Conagra judgment, you didn't need to file one of those relief from judgment motions, did you?
Well, technically, but I don't think we should be penalized for being extra cautious either.
I see.
So, yeah. We tried to get it acknowledged that this was not accurate, and it's a proper Rule 60 motion. Now, however, the federal district court stated the 10th Circuit has told me that I don't have jurisdiction. I don't have jurisdiction to proceed. And then the case remanded to Wyandotte County, where we proceeded for 2 years prior to this judgment. So it's extremely peculiar, and it's just, yes. It's very strange, but it is a conundrum because a court without jurisdiction cannot impose a judgment or cannot impose a judgment against a party, and the court did not have jurisdiction. And just as the addition, whether Kraft and Safeway were in front of the 10th Circuit, it still wouldn't have had jurisdiction. So
okay.
It is a void judgment. There is no
counsel at some point though, that those jurisdictional realities give way to courts' needs for finality, right? At some point during the process, say this case ends, parties can't 5 years down the line say, yeah, but the court didn't have subject matter jurisdiction and thus attack the judgment in that way. Would you agree?
Well, I accept that subject matter jurisdiction is an argument that can be raised at any time, and that's just the reality. That's just the law on that particular issue. And yes, there is a need for finality in cases, and this case might be the ultimate example of this because it dates back to 1991. But at the same time, the parties are entitled to finality on the merits, and should not be a court that does not have jurisdiction, that judgment cannot be binding against them.
Would you agree that the jurisdictional question was a debatable question? It was an open question at the time until the U.S. Supreme Court finally resolved that, right?
I in some ways you could argue that at the same time, Americold never made sufficient allegations as to the jurisdiction. So arguably there was not a basis for subject matter jurisdiction at the time that they filed their notice of removal. There was a legal question about it before the 10th Circuit, which was a valid legal question. But at the same time, it still does not mean that the court had jurisdiction.
Counsel,
And
you have a few moments left in your, and I have a question that I want to, that's just burning up for me. If it is not res judicata, is it the law of the case?
well, I don't believe that is true either. And because it's not res judicata, it does not fit in the whole of res judicata. It does not fit in the whole of law of the case because there is no law of the case here. One, the law of the case is not a binding legal rule of law. It is a discretionary.
Well, the U.S. District Court granted summary judgment against your two clients, as well as against Conagra. And that was never appealed. And that's the rule in that particular case, is it not? And would that not fit into the rules that we have concerning the law of the case? Because let's assume you're correct. And this is all one case that started way back when in 2013, you say. Why wouldn't that be the law of the case that where the district court could be right for the wrong reason?
Well, one, that's not what the district court did here. And the district court, if the district court wanted to apply the law of the case doctrine, it should have made that determination, which it didn't. And that issue is not really part of our interlocutory appeal today. But two, it cannot be the law of the case if it is a vacated judgment. It is no longer a judgment that is in place. It is void. It was made without subject matter jurisdiction. And so I believe you said earlier that it cannot be the law of the case when the judgment does not exist anymore. I mean, this may be just one of a very strange situation where this case has to go on because it doesn't fit within one of the doctrines that would bar the claims. And that's what we're arguing here. It doesn't fit with any of these doctrines. And unless the court is inclined to make up a new doctrine, there's no reason that this case should be dismissed. Now, there's nothing to keep the district court from taking up the issue and deciding, saying, I agree with Judge Lundstrom, but that's not what the district court did here. The district court found that it was barred by reason of res judicata, which doesn't apply here. And the district court was wrong to do that.
Counsel, you've got about 2 minutes left. If you want to sum up before your rebuttal, you'll have your entire rebuttal time.
I believe I will let it sit on that and reserve my time for rebuttal. Thank you.
All right, very good. Thank you, counsel. All right, counsel, we'll hear from the appellees.
Thank you, Your Honor. Appreciate it. And Judge Hill, you're exactly right. This is a law review exam if there ever was one. But I will tell you, fortunately, whatever way we look at this.
Hold on here. For some reason, the recording stopped.
I think we lost our attorney who was handling this. That's what I saw.
Well, I don't know if we should proceed or not.
Here we go.
All right, I think we're back and running. Okay, very good. We had a brief delay there where our recording stopped. All arguments stopped at that time. Counsel will proceed with your argument on behalf of the appellees.
Thank you, Your Honor. Whatever way we cut this, whether it's res judicata or a law of the case, I think the result's going to be the same. Judge Warner hit it right on the nail on the head. There's got to be finality eventually at some time. This case involves a fire that started back in '91. I was still in college back then. This thing's lasted forever. And opposing counsel's right. This thing went all the way up to the Supreme Court ladder, all the way back down. And Judge Warner is also correct that during that time, Kraft and Safeway stepped off that ladder. Anytime all they had to do was file a simple one-page notice of appeal, they could have even had a Me Too brief with Conagra. but they didn't do it. They picked up their chips and they went home. Conagra continued the appeal. At that time, when we got to the 10th Circuit, the question of whether it was arguable whether or not subject matter jurisdiction existed in Lundstrom's court, Judge Lundstrom, absolutely it was arguable because nobody raised it. We got to the 10th Circuit. The 10th Circuit sua sponte said, brief this issue. Conagra's counsel and myself looked at each other and said, what's going on here? Of course there is. And we told the court that. Nevertheless, the court ruled the way it did. The Supreme Court took the case to say, hey, we got to decide the split because some courts are doing either way. They took the case. As we know, they affirmed the 10th Circuit. 10th Circuit sent its mandate down. The law is clear, Your Honors, that a court of appeals.
Could I ask a question? I mean, it seems to me the significant thing is what happened after that in 2016 in front of Judge Lundstrom. As I read what he entered at that time, it's an unconditional vacating of his 2013 judgment, isn't it? I mean, there's no limitation on it. He said, I'm vacating the 2013 judgment and I'm sending this. Well, that's what he said, isn't it?
Yeah, but Judge, there is a limitation as a matter of law because a court of appeals can only have authority of the parties before it. When it sends the mandate down, the mandate affects the parties that were before that court of appeals. And so,
but Judge Lundstrom, you're saying Judge Lundstrom didn't conform to the mandate.
I'm saying Judge Lundstrom did what he had to do. He just said, I have no authority in this case. You know, the mandate says my judgment.
And he vacated the 2013 judgment, right?
But he could not have done so as to Kraft and Safeway. And here's why.
Well, but he did.
But
I mean, it doesn't, well, the judgment that he entered in 2016 doesn't carve out Kraft and Safeway. He has vacated the entire judgment, right?
Yeah, his mandate does not mention Kraft or Safeway at all. That's correct.
Right. Okay.
There's no specific carve out whatsoever.
So, read on its face, it vacated the entire judgment. And rightly or wrongly, whether that's what he was supposed to do or not, that's what he did. And isn't the effect then that the 2013 judgment doesn't exist now? I mean, he may have made a mistake, but that the result is that he vacated it in its entirety. Right?
No, Your Honor, I respectfully disagree.
Okay, show me where that isn't. I mean, where does he say that that's not the case?
He doesn't, Your Honor, but the case law is clear. The case law is clear that if you do not appeal an order and time to appeal runs, you are bound by that order. If their subject matter jurisdiction is challenged later on by a co-party and that co-party wins.
Well, I understand that theory. And you're saying that Judge Lundstrom didn't do it right.
I suppose that's correct, Your Honor. I still think.
But Americold didn't file anything in the federal district court asking for that to be reconsidered.
No, we didn't have to. We did not.
Okay. I fail to see how there is a valid, enforceable remnant of the 2013 judgment. I mean, Lundstrom may have messed it up. I'm not sure that he did, but he may have. And his 2016 judgment is rather clear on its face. So I don't know what we do with that. I mean,
yeah. Your Honor, I would just go back to our arguments that a failure to appeal means you're bound by that. And all I can say is I hate to be repetitive, but the 10th Circuit could only do what it could do with Conagra before it. At the time it went back, the only thing to avoid was the remaining judgment that existed, and that was against Conagra.
Counsel, I have a question for you.
Yes.
What we have before us is the state district judge's very brief ruling saying res judicata bars any further proceeding. I see our recording has stopped again.
Hold that thought.
Yeah.
It was not me.
I think we're having internet issues with the transcriptionist. Well, anyway, my question is this. Res judicata is usually applied in a second case. And it seems to me that your opponent makes a very valid point that this is not a second case. This is the same case that has lived so long, but it's still the same. It might have a gray beard, but it's still the same case. So res judicata couldn't apply, could it?
I think it can, Your Honor. And I think res judicata can apply, Judge, and here's why. Res judicata does require a separate action. We believe the action against Kraft and Safeway was done in the federal court when they failed to appeal. We think that judgment is binding on them. When the case went back to Wyandotte County, when we showed up, I was shocked to see Kraft and Safeway there. They showed up and said, we're part of the case, let's go forward. I filed a motion to dismiss right away saying, res judicata, law of the case. Judge said, well, let's take this up at a later time, which is why I moved for summary judgment on the issue. So I do think it's a separate case. I mean, it's not titled a separate case, but in all due respects with regards to Kraft and Safeway, it is a new action. Secondly, even if it's not, I think the law of the case would also apply as well. What we have here is, if we're assuming this is the same case, we have a ruling on the merits by Judge Lundstrom that was not appealed by Kraft and Safeway. That ruling could have been appealed, but it wasn't. As such, if this is still the same case, that becomes law of the case. And there's a case that I'd like to refer the court to. It is the State versus Finical case. It's a Supreme Court case in Kansas from 1944.
What was the case again, counsel?
State v. Finical, F-I-N-I-C-A-L. That court says, once the issue of jurisdiction is raised, although a party may raise lack of subject matter jurisdiction at any time, a party may not raise it many times. When an appealable order is not appealed, it becomes law of the case. So the merits decision by Judge Lundstrom was a merits decision. It was not appealed. As such, as to Kraft and Safeway, if this is the same case, it becomes law of the case.
That was the precise question that I asked you, your opposing counsel. For those two defendants, that was a ruling upon the merits, and that is the law of this case. I don't think it's res judicata, that's the law of the case. And they had a chance to appeal that and did not.
Correct.
Now, what jurisdiction did Lundstrom have to dismiss those two judgments if he was simply following the mandate rule? Because the only thing he got back from the 10th Circuit was the case that the 10th Circuit had, which was only the judgment concerning Conagra.
Correct.
Am I correct on that?
You're correct. So Conagra is still in the game. If Kraft and Safeway considers themselves still in the game, well, they're bound by the decision that they didn't appeal. Conagra is not, because Conagra successfully appealed that. Kraft and Safeway cannot jump on the coattails of an appealing successful co-party, which is Conagra.
Now, there is a line of cases, is there not, that says when you have parties that did not appeal that are so inextricably bound up, they get the benefit of the appellate ruling because they're so closely identified with the successful appellant. Are you familiar with those cases? And if so, does that doctrine apply to this particular case?
I am not familiar with those line of cases, Your Honor. I mean, quite frankly, I wouldn't think it would apply because each party stands on their own. I mean, if they wanted to file a joint notice of appeal, they certainly could have, but they didn't. And so the fact that two of the three plaintiffs, thought that it was time to wrap up and go home, that's the decision they made and that they live with. If Conagra could have made the decision to appeal and spend $100,000 and lost, well, then Kraft and Safeway would say we made the right decision. But it's the opposite. Kraft and Safeway.
I'm referring to a case in the Kansas Supreme Court several years ago, an opinion written by Justice Six, where where the court was overruling the Court of Appeals when they were determining some mechanics liens and whether or not they took precedence over a purchase money mortgage because of the failure of the mortgage holder to record it before the mechanics liens had been recorded. And there were mechanics liens people who did not appeal to the Supreme Court, but the Supreme Court says, look, you're so inextricably bound with this, you get the benefit of our ruling today. So you're not familiar with that particular case?
No, I'm not, Your Honor. I could kind of see maybe the situation where you're talking about a mechanics lien where there's like one particular property at issue, or maybe one, I don't know, building with many subcontractors and different mechanical liens and stuff like that. I can see that maybe it might be a little bit different. But here, each of the plaintiffs had separate individual causes of action against Americold. And so it wasn't like Kraft relied on Conagra for their causes of action. With all due respect, I did not read Justice Six's opinion. I'm not familiar with it, but I can kind of see some differences sitting right here between that situation and a typical run-of-the-mill breach of contract claim.
Because the facts here were you had Americold, the real estate investment trust, Kraft had items stored in there, and Safeway had items stored in there, and they had the fire, and there was a settlement agreement. And basically this was a lawsuit over a breach of the settlement agreement, correct?
Correct.
Huge fire, lots of losses.
Right.
Yeah, all right.
But Your Honor, each was suing on their own, each of them had their own consent judgments for their own damages. Yeah. They were all separate apart. There was one settlement agreement, but it was based upon they contended they were trying to enforce via this action.
So you would argue that that is factually different than the case I was referring to?
I would, again, sitting here respectfully without having read Justice Six's opinion.
All right, thank you.
The final thing I'd like to say, if I could, is one of the final arguments that Kraft and Safeway are making against the law of the case argument is that the decision was erroneous. I would just point out, I don't think Judge Lundstrom's opinion was erroneous at all on the merits. He essentially followed the court's ruling in Americold 3, which is one of the cases this went up before, basically saying, hey, if you don't revive a judgment in time, it remains dormant. If you don't revive it within that 2-year period, you're done. That's what he held. He just followed the law. So to the extent that we look at law of the case, I do not think that a defense to that would be that Judge Lundstrom's opinion was erroneous. Unless the court has, I'm sorry, Judge.
No, that's fine. Any other questions? Okay.
Thank you, Your Honor.
I don't see any, counsel. As I said before, we won't penalize you for not using your whole time. All right, let's hear from appellant's counsel. And counsel, you've got your 5 minutes.
All right, thank you.
Before you
go
get
ahead.
into that, I wanted to follow up on something you said at the tail end of your argument, and I want to be sure I understand your position. If we were to agree with you and essentially send this case back to the Wyandotte County District Court, there is nothing to prevent Americold from proceeding on a merits argument based on Judge Lundstrom's 2013 ruling. I mean, basically arguing Lungstrom's a smart guy. He construed these statutes. Here's what he said. You should do the same thing. They can do that.
Correct. They can do that. They can file that motion. Our clients can respond, and the judge can make rulings on those issues. And I believe they did file those motions. The judge did not make those rulings. So there is no reason, but those issues aren't before us today. But yes, exactly. The case can proceed, and Americold is not deprived of its arguments on the merits or arguing that Judge Lungstrom was correct. You can absolutely do that, but that is not what has happened here. And
no, I understand that. I want to be sure you're not claiming that there would be some bar to Americold raising a merits argument now on the effect of the dormancy and reviver statute.
That would be inconsistent with our position that the judgment in 2013 was vacated by the federal district court. So, and it has no bearing. So they could take it up and we could respond accordingly. One thing I wanted to say after counsel's argument is I have a disagreement with his statement that the law is clear on this. I don't believe the law is clear on the result here, and the court has its work out for him. But it appears to me that there are two separate lines of case law that come to a crossroads here, and there's nothing out there to state what happens when these two differing types of opinions merge. You have case law on parties who do not appeal and are then penalized because they can't take the benefit of what happens in a subsequent appeal. None of those cases involve subject matter jurisdiction. None of the cases that Americold decided to the court. And I think that's an important distinction here. And then you have the line of case law involving subject matter jurisdiction, where the courts say subject matter jurisdiction is never waivable. Judgments entered without subject matter jurisdiction are void. None of these cases show what happens. What if this first decision was made that's not appealed, was taken by a court that didn't have subject matter jurisdiction to enter that decision? And that's what happened here.
That's why it makes a wonderful bar exam question.
That is why it makes, yes, and that is why it is not an easy question, and the law is not clear, because none of these cases, including the case, I just looked up the case, counsel didn't cite it in his brief, but this Pinnacle case, it's 254 Can 529, by the way. It does not address this. That is a case where it is a criminal case where the state was bound by the failure to appeal an issue. And then the court said, well, it's later law of the case, but there was not a subject matter jurisdiction.
Could you give me the site again, please?
Oh, excuse me. It is 254 Can 529.
Thank you.
But the initial judgment, unlike the case here, is not clouded by subject matter jurisdiction.
Counsel, let me ask you a hypothetical question. What if instead of these two or these three parties all being involved in one lawsuit, right? Let's say hypothetically you had two different suits. You had a suit that involved Kraft and Safeway, and you had a suit that involved Conagra. And otherwise the facts are the same, right? So you've got Kraft and Safeway who have a final judgment on the merits from the federal district court. They don't appeal. And you've got Conagra in this separate suit who has a judgment against it, appeals, and we find out that the court lacked subject matter jurisdiction in that suit. Could Kraft and Safeway then reopen their judgment in light of this separate subject matter jurisdiction ruling?
Well, I think that they would be able to file a motion in their case to reopen it, because you can never waive subject matter jurisdiction. You could file, if it was still in the federal case, or actually in either court, you could file a Rule 60 motion or a 260 motion and use that argument. But that would be a collateral attack, which is not the case here. And it is different. And you also do not have the order of the federal district court that we have here, the unconditional order.
Yeah, I understand that the facts are different.
Yeah.
I'm trying to figure out where the difference lies.
Yeah, it is different. I believe that a party could file an attack of that, and they would have law to support them that this initial judgment was made without subject matter jurisdiction. But I think the question is different. And
Well, you filed that motion, but it got swept away by the U.S. District Court, didn't it?
we filed that motion in our same case. Yes, as parties to the same case. The hypothetical is that we would have separate cases, but yeah.
But you filed that motion asking for relief from judgment, and the court just swept it away,
Yes.
saying I don't have jurisdiction to do it.
Yes.
Well, okay. Well, listen, counsel, we've asked you several questions. If you'd like to take a moment to sum up, please do so.
I believe that if the court is going to dismiss the claims of the party, that dismissal needs to be based on an established rule of law. There is not an established rule of law in this case that supports the dismissal of Kraft and Safeway's claims before the Wyandotte County District Court. The rule of res judicata doesn't apply because it's not a later case and the initial judgment was void. The rule of law of the case does not apply because there is no law of the case. The October 2013 judgment by the federal district court was later vacated. So absent an established rule of law, the ruling by the district judge of Wyandotte County on the basis of res judicata was erroneous and should be overturned. The case should be returned to Wyandotte County for further proceedings.
Thank you, counsel. Very interesting case.
Yes.
We'll take it under advisement and issue